There is no requirement for the female employee to be married, yeah, by the way, because the law just says that she delivers, right? So there may be some moral issues behind that, but from a legal aspect, no, as long as she delivers. There's another requirement, of course, that there must be a minimum of 22 weeks of pregnancy. Even if the child was born, unfortunately, the child, it was a miscarriage, the female employee is still entitled provided she had at least 22 weeks of pregnancy. So once you go more than 22 weeks of pregnancy and you satisfy these conditions, you are entitled. But there is a limit. There is a limit. The law only provides for maternity leave if the employee does not have, if the employee has not more than 4 or more surviving children at the time of confinement. That means if female employee, Miss A, has got 4 surviving children at the time, on the 10th of October, she's fine. If she delivers, she's still okay, because not more than 4 surviving children. But if on the 10th of October she has got 5 surviving children and she now delivers again, she is not entitled to maternity protection. What does that mean? You don't have to give her 60 days of leave. She can still go on unpaid leave. It's not paid leave. Right? So the requirement is not more than 4 surviving children at the point of confinement. Which means here, for example, if a female employee delivers 5 children at one go, game over, the quota is habis. Right? So that's the requirement of the law. So this part I can show you, I can say that 99% of my clients never knew this. They all felt, I only have to give maternity leave if the employee is working with me. That's not the case. The law does not provide that. Yeah? Okay, so that's the Employment Act. It's a very, very technical act, I can assure you. And I can tell you that if I was a GTK officer, it will be easy for me to find faults in employers. You know, like for example, there is you cannot make deductions from salaries as and when you like, even if the employee agrees. Let us say I've given my employee an advance of 3 months' salary. He wanted a loan. I give him 3 months. I cannot make deductions from his salary, automatically. The law prescribes when you can make deductions, even though they agree. A lot of times we think that if the employee agrees, we can do whatever we want. That's not the case. The Employment Act does not allow you to circumvent the law even though the employee agrees. So let's move on from the Employment Act. I want to move into the Industrial Relations Act. This is the one where I think there is greater risk for employers. What is the intention of the Act? As you can see, very high level. It is attempting to maintain harmonious relationship so that employers and employees can work together for the betterment of society and so on and so forth, right? Now, the Industrial Relations Act, unlike the Employment Act, applies to the whole of Malaysia. Employment Act only Peninsula and Labuan. Industrial Relations Act, the whole of Malaysia. And if you notice, it says to all categories of workmen. You know the 4 categories I talked about in the Employment Act just now? Forget about that. For this Act, so long as you are employed under a contract of service, the Industrial Relations Act applies. Whether your salary is 1,000 ringgit or whether your salary is 150,000 ringgit, it doesn't really matter. Right? That is why, if you notice, the Employment Act uses the term employer and employee, whereas the Industrial Relations Act uses the term employer and workman. Sort of a distinction between the Act, Industrial Relations Act, and the Employment Act. Yeah? And it applies to all nationalities. It does not cover only Malaysians. Employment Act as well. So you may have your Bangladeshi workers, your Indonesian workers, the Employment Act applies. Likewise, the Industrial Relations Act. The Minimum Retirement Age Act, that specifically mentions it does not apply to, it only applies to citizens of country, of Malaysia. The Minimum Retirement Age Act does not apply to foreign nationals. But the Industrial Relations Act, the Employment Act, it does apply. Okay, so let's drill down a little bit. Do you have a clause like this in your contract, something which states either party may terminate the contract by giving X months notice, or by paying X month's salary in lieu of notice. Do you have a clause like this? Yeah? Okay. Did you agree to this clause? Doesn't matter now, you signed the contract. That means you agree. I can share with you a very, very old English case, Lestrange and Grocott. I think it's more than 400 years old, where a blind guy went to court and said he breached his contract. It wasn't a contract of employment, yeah. He did not comply with the terms of the contract. He went to court and he said, yeah, I didn't comply with the terms because I don't know what the terms are. I'm blind. How can this contract apply to me? You know what the court said? Did you sign the contract? He said, yes. The court then said, well, if you sign the contract, I will have to assume that somehow you came to know of the terms and agreed to it by signing. So moral of the story, if a blind guy cannot avoid the contract, you have no choice. Right? The contract applies to you. So this term applies to you guys. So let's understand this term. Either party, who are we referring to? Employer and employee, right? There are only two parties to your employment contract, the employer and you. And it states you want to terminate the contract, no problem. There are two ways you can do it. One would be by serving notice. The other would be, even if you can't serve notice, not a problem. I give you my notice today, and today is my last day, I pay you my salary in lieu. No problem. That's what the contract provides. And because it says either party, if the employer wants to terminate, same thing, serve notice or pay salary in lieu of notice. Correct? Now, so if I were to ask you, is it easy or difficult for you to resign from your employment? Easy or difficult? Easy, right? Do you have to give a reason to your employer why you're resigning? I hate my boss. As good a reason as any, but don't put that down in writing. Yeah? But you don't have to give a reason. Because the clause states, you want to terminate, you just give notice. If you want to leave immediately, no problem, pay salary in lieu. And the clause goes on to say, either party. Employer also can do the same. So what is the problem? Why was Roy talking about high awards in courts? Doesn't seem to make sense, right? Because it seems very, very simple. I think we sort of agree that the clause seems to say, if you want to terminate, there are only two ways. Serve notice or pay salary in lieu. You guys agree with me, it's easy for you to resign. That's what the clause means. So, if I ask you this question, is it difficult to terminate an employment contract? Yes or no? See, even though I've just sort of demonstrated it's easy, some people here say it's no, it's not easy. Because we've heard somewhere it's difficult. Okay, the problem, what makes it difficult is this provision. Section 20, subsection 1 of the Industrial Relations Act 1967, which states, where a workman considers that he has been dismissed without just cause or excuse by his employer, he may make representations in writing to the Director General to be reinstated in his former employment. The representations may be filed at the office of the DG nearest to the place of employment from which the workman was dismissed. This is typical legal language. Notice there is no full stop until right at the end. Because legal language, the design philosophy was to confuse. And I think I personally am thankful that it's not easy, because if it was, susah for me to cari makan. So how does this work together with the termination clause? This one now says, yeah, notice where a workman considers that he has been dismissed without just cause or excuse, he can file a complaint. He files a complaint asking for what? Reinstatement. He wants his job back. Now, seems to be a bit of a contradiction, because earlier the clause that we signed does not say you have to terminate with just cause or excuse. Remember, I asked you, do you have to have a reason to terminate? You said no, because the clause doesn't say you have to have a reason. But now section 20 states, if an employee considers, and that's a very important word, where a workman considers, if an employee considers that he has been dismissed unfairly, what can he do? He can file his complaint. which now suggests an employer can only terminate the contract with just cause or excuse. Right? Because now section 20 says this. Because if it's without just cause or excuse, employee files a complaint, he can potentially get his job back. So can you see there's a contradiction? This clause now states, or this provision states, employer, if you want to terminate, you must terminate with just cause or excuse. The contract says, no need to have any just cause. Suka, you can terminate. So which applies? There's this provision which was passed by Parliament in 1967, or the contract which you personally read, understood, agreed and signed off. What do you guys think? The law lah. The law will supersede the contract. We cannot use a contract to avoid the law. For example, let us say I entered into a contract with Mr. A. I say, okay, Mr. A, I want you to break Mr. B's legs because Mr. B is my enemy. So Mr. A says, how much will you give me? I'll give you 5,000 ringgit. I don't trust you to give me this. Okay, let's sign a contract. You break Mr. B's leg, I'll give you 5,000. I sign, he signs. He goes and breaks Mr. B's legs, and I give him the 5,000. Police comes.